I call the honourable member
Mr.
Dennis O'Rourke.
Thank you, Mr. Chairman. This bill is the most objectionable and draconian bill this government has produced in this term, in my view. In part one, not only are there very extensive powers of investigation of existing tenants or any prospective tenant to see if they remain eligible for income-related housing, but there are several new clauses which effectively set up Housing New Zealand as New Zealand's housing police and authorise Housing New Zealand to set aside the Privacy Act, showing yet again how the national government has little regard for privacy in this Act, as it did in the much reviled GCSB Act recently pushed through this House. Clause 14, new section 59, for the purposes of Housing New Zealand reviews says that, quote, Housing New Zealand may request any person to A, answer questions, or B, allow Housing New Zealand to inspect any document, C, give Housing New Zealand 1, a copy of any document or other written information, or 2, a printout of any information stored digitally. And quote 2, the person does not have to comply with that request, but for the purposes of section 7.1 of the Privacy Act 1993, this subsection authorises the person to make personal information available in response to the request. So much then for personal privacy in New Zealand with legislation like that. And it proves the provision effectively nullifies the Privacy Act, and it is unnecessary when Housing New Zealand can satisfy itself in other ways about the eligibility of a person for housing without compromising the Privacy Act in that way. Under new section 59AA, Housing New Zealand may require information for certain purposes. Housing New Zealand may, by written notice, require information from any person concerning housing assessment or reviews, and in, quote, F, the purpose of determining and detecting whether a person has committed or is committing an offence, and in, quote, G, the purpose of determining and detecting the cost of fraud, and in, quote, H, the purpose of ascertaining whether a person has failed or refused to answer fully or has deliberately given a false or misleading answer to any question, unquote. In requiring such information, Housing New Zealand must do so only in accordance with a code of conduct. But, I quote, any person from whom information is required must comply with the requirement no later than 5 working days and without charge. The only exceptions are that the section does not require any person to provide any information or require any document that would be privileged in a court, or require any person to provide any information or produce any document that is legally, professionally privileged. And it does not apply to financial information such as receipts or financial transactions. But, Mr. Chairman, that still leaves a lot of information which any person must provide when required to do so. That information is then used for reviewing the eligibility of tenants, terminating a tenancy, and reallocating or reassigning Housing New Zealand housing to a tenant. The offences are in new section 61AB, under which is an offence for any person not to provide information required by Housing New Zealand, and there is a fine of up to $2,000 for that. And it's an offence to mislead Housing New Zealand. It's even an offence for any person to deliberately omit to do or say anything if the purpose is for another person to be eligible or continue to be eligible to be allocated Housing New Zealand housing. For this heinous crime, any person who does so commits an offence and is liable to imprisonment for a term not exceeding 12 months or to a fine not exceeding $5,000 or both. The only redeeming provisions in this draconian part of the bill and Act are those relating to the Code of Conduct and the role of the Privacy Commissioner. But overall, Mr Chairman, the impression is given that the State House tenants under National's Amended Act will be treated much more like the inmates of the Gulag Archipelago than tenants needing respect, security and long-term housing solutions, instead of being constantly subject to reviews and investigations. Mr Chairman.
I call the honourable member Jan Logan.
And I too would like to speak to some of the